Hey everybody, how's it going? Hope you're having a lovely day. I've been going over this law on this channel for a while called Section 12.1 of the DMCA. Section 12.1 of the DMCA is the part that says if you break a digital lock to gain access to a protected work, that if you show people how to do that, you can get 3 to 5 years in federal prison. It's a really horrible law. It was designed to combat piracy, and now that everything that you own connects to the internet and has digital locks and DRM in it, it's no longer about this person's trying to, pirate the Matrix and sell copies of it to millions of people. It's about, I want to get the ads off of my fucking fridge and my TV, and I'm not able to fix my tractor. This law has outlived its usefulness, and in my opinion, this law, dare I say it, never had any usefulness. I've started a nonprofit dedicated to trying rolling it back and try and reform it, and we've been doing quite a bit of work over the past year to do so. We've been working with lobbyists, we've been working with politicians, we've been working with lawmakers, and frankly, I'm very interested in trying to find a test case. We have been promoting how ridiculous this law is through our bounty program. Our bounty program is where there are devices that have horrible, absurd cases of digital locks on them, and we will pay people to break them. And if they choose to share the solution, great. If they don't share the solution, then we have a great example of how this law is causing real and actual harm. Now, a case came across my desk recently that I'm very interested in. It deals with a First Amendment auditor and somebody who's very critical of First Amendment auditors. Now, you may wonder, Lewis, what the fuck does any of that have to do with Section 12.1 of the DMCA? I didn't have any idea until I started reading the case. The TLDR of this, and I'll leave it to Leonard French if you want the full legal definition. He's way better at doing all that. I'm not going to read through every single element of the case. Leonard French is a lawyer. He's a copyright lawyer. He's going to do a better job of that than I ever could. I'm just going to give you the TLDR. You have a gentleman who runs a YouTube channel called Denver Metro Audits. He does First Amendment audits. First Amendment audits is this thing where you will have a camera and you'll walk up to the police or a public place or a public building or go into a library and you'll record and you'll see if you get in trouble. And the idea behind it is that I have a First Amendment right in the United States of America to film a public building. I have the right in the United States of America to film the police. And if you're not allowed to film the police, if you live someplace where the police can tell you, hey, you can't film us, stop that, that's illegal, that's tyranny. And I understand that. The First Amendment auditors may not always necessarily come across as nice and kind and caring, but they're there to try and check and make sure that your rights are intact. There are some people that go a little too far with it, that just are just doing this to fuck with people and get attention and, create annoying scenarios for people that don't want to be recorded and be obnoxious about it. And that is where channels like the Frauditor channel comes in. Frauditor is a channel that is very highly critical of a lot of the tactics used by many First Amendment auditors, and he does not pull any punches. Now, there are valid points to be made on each side here. Again, I want to live in a country where I can record the police. So if you can't record the police, if they have the ability to take out their baton or just start shooting you and you take out your phone to record them, that's pretty fucking bad. Simultaneously, there are a lot of First Amendment audit channels that I see where it looks like some shit resembling like FuzzyTube circa 2015. It's a distasteful prank channel, and it's just fucking annoying.
We got Tyrant Hudson here.
Hey, how are you doing?
From last time, the douchebag. This clown right here. Freaking clown right here, man. Let's follow him around.
Where you stand on this type of content doesn't really matter to me. What matters are the legal arguments being used to try and get somebody's video taken down. So Frauditor is criticizing First Amendment auditors very often. And to criticize them, he has to show their content on his channel. So he shows the content on his channel and he gets a takedown claim from Denver Metro Audits. And again, they're going through the process. He filed a DMCA claim. Frauditor responds to it. They're going through the process. And he says this is fair use. Denver Metro Audits says no, it isn't. And then when Frauditor gets his videos reinstated, they mostly got reinstated, Denver Metro Audits says, that's not good enough. I'm going to sue you. But he doesn't just sue based on fair use. That's not good enough. He sues based on fair use and Section 12.1 of the DMCA. Now, where does a law about breaking digital locks have to come in to a YouTube copyright dispute amongst two people who disagree on politics? Well, in order to show the video on screen, Denver Metro Audits is alleging that Frauditor had to download it. And the process of downloading a YouTube video, you may notice on this video, there's no download button. And even if you do have a download button because you pay for premium, it's not a real download button. It's this bullshit download button where it only works within the YouTube app and this, that. It's not giving you an MP4 or an MKV file that you can do whatever you want with. It's there to control access to the work. Now, there are programs like YTDLP, YouTube Downloader, that are great. This is a lovely program. It decrypts the URL stream and allows you to download a real copy of the video, which I support. I have no problem with people downloading copies of my videos. If YouTube goes away, I don't want the entire fucking collection of everything I've created to be gone. There are some creators in this platform where, like, again, if YouTube, there are videos that have really, really helped me. So if YouTube goes away, I don't want that content to just disappear into the ether because of this law. So YouTube Downloader exists, but because of Section 12.1 of the DMCA, because it is breaking a digital lock, you have to understand that That program that you love, that even if you don't use it, many of the programs you use to download YouTube videos are using it, is technically breaking that law, which means the people making that program could be subject to 3 to 5 years in federal prison if they're doing it in the United States. So after Frauditor's videos get reinstated, he decides, okay, I need a better argument than just that he's not doing fair use argument. And when he sues him, now he starts trying to make the Section 1201 argument. Claim 4, circumvention of technological protection measures. Mr. Cordova asserts a claim for unlawful circumvention of technological measures in violation of Section 1201. Defendants argue that the claim should be dismissed on 2 grounds: lack of standing and failure to adequately allege defendants circumvented any technological measure. Section 1201 prohibits the circumvention of any technological measure that effectively controls access to a protected work. To state a claim for violation of Section 1201, a plaintiff must plausibly allege that the work at issue was protected under the Copyright Act, the copyrighted work was protected by a technological measure, and the technological measure was circumvented in order to gain access to the copyrighted work. The court first considers defendants' arguments that Mr. Cordova lacks statutory standing to bring a Section 1201 claim. This lacks merit because they say that Section 1201 affects anybody that's been injured by this, and Mr. Cordova alleges injury based on the defendant's alleged circumvention of technological measures. The court next considers whether Mr. Cordova has adequately pled claim for violation of Section 1201. Defendants argue that FAC does not plausibly allege that the videos were protected by a technological measure when published on Mr. Cordova's YouTube channel, or the defendants circumvented any such measure in order to obtain access to the videos. Now, technically, these were protected at the time because you can't download, like YouTube does this to every single video. Every single video uploaded to YouTube. It's not like they make one where it's like, okay, this one will work with even old versions of YouTube Downloader. It's not like that. Google, YouTube, and YouTube Downloader are in constant fights with one another. So Google will fix it so that YouTube Downloader doesn't work. YouTube Downloader will reverse engineer what Google did and make the program work again. Every single video on YouTube is protected by this technological protection measure. I'm not saying I'm defending it. I'm just saying that that's the case. The DMCA defines a technological measure that effectively controls access to a work as a measure in the ordinary course of its operation requires the application or information or process of a treatment with the authority of the copyright owner to gain access to the work. According to the FAC, YouTube automatically applies technological measures to publishing videos that control access to and prevent unauthorized copying or downloading of Mr. Cordova's videos. The FAC alleges that YouTube's technological measures include rolling cipher technology, which is software designed to prevent unauthorized downloading of videos. This technology encrypts and dynamically alters the video stream's URL signatures to prevent unauthorized downloads. Citing MDY Industries, defendants argue that Mr. Cordova's claim fails and YouTube's technological measures do not effectively control access because Mr. Cordova's videos are publicly available on YouTube. Defendants misread MDY Industries. As the Ninth Circuit explained in that decision, the statutory definition of the phrase effectively control access to a work does not require that an access control measure be strong or circumvention proof. Rather, it requires an access control measure provide some degree of control over access to a copyrighted work. Mr. Cordova has adequately pled that YouTube applies technological measures, including rolling cipher technology, designed to prevent unauthorized downloading to videos published on his platform that effectively control access to his videos for purposes of Section 1201. Whether the videos may be viewed by the public is immaterial. The FAC refers to technological measures intended to prevent unauthorized downloading of the video. And Denver Metro Audits is technically correct over there. That technology prevents you from being able to download. And the problem is not YouTube preventing you from downloading videos. The problem is that if somebody comes up with something that reverse engineers YouTube's method and just grabs the video, that is punishable by 3 to 5 years in federal prison. What the people at YouTube Downloader did is math. This law makes math illegal. The math for DCSS, for you to be able to get around the encryption in a DVD, is something that, like, you could put this on a t-shirt. It's insane, the idea that this is illegal. And at some point, I believe the EFF, I think 20, 21 years ago, actually did make a t-shirt, something along the lines of this shirt is illegal because it included a math equation on it. According to the FAC, defendants circumvented YouTube's technological measures by using software applications, ripping utilities, or browser extensions specifically designed to bypass YouTube's technological measures. Mr. Cordova alleges that defendants' tools retrieve and decrypt the obfuscating URLs, and they just kind of go back and forth on this matter. Now, here's the thing that gets me. Firstly, this is aside from the Section 1201 part. Firstly, if you are a First Amendment auditor, you care about free speech, again, to the point where you are showing up to you are showing up to libraries and recording people doing shit like this.
We got Tyrant Hudson here.
Hey, how are you doing?
From last time, the douchebag. This clown right here. Freaking clown right here, man. Let's follow him around. Look at all these kids around here, and he's saying effing and acting like this.
Because you're recording around children, and that's totally against everything I'm a belief. You know what?
Oh,
Get the fuck out of here! Go!
Chad, calm down. Wow.
I don't believe in filming children.
We weren't filming kids. We weren't filming kids. Look, he's acting up again.
When you believe in the First Amendment to that extent, and like this is your content, it's really hard for me to square the circle of you also being the guy that's like, that person re-uploaded my video and he was not nice to me. He used 40% of my content and criticized me. That's like, really? Like, this is a video on my channel. If you're gonna be the bitch, be the whole bitch. If you are that into the First Amendment that your entire channel is nothing but First Amendment audits, yet somebody re-uploads a portion of your video to their channel and is critical of you, and you're like, oh God, let's take that down. Like, that's bitch shit. That's bitch shit. You filed your claim with YouTube. After filing your claim with YouTube, YouTube determined that the video was fair use. Which, by the way, YouTube never fucking does. YouTube almost always agrees with the person filing the strike. But you lost a YouTube strike. After you lost it on the merit, now you're going to try and also, again, be like a Weasley little bitch with it. And then try to say, oh, well, you had my video on screen. Well, how'd you get my video on screen, huh? Well, you must have broken the DRM. So I'm going to get you for breaking the DRM. Like, no. Because no, that's not how that works. Because there's other people on YouTube that have used videos from this channel. How many fucking people have you sued for that? How many? How many people, Denver Metro Audits, that have used a piece of your fucking video on YouTube have you sued because they used YouTube Downloader or screen capture software to show your video on their channel? You didn't. This is a fair use or copyright issue. This is a censorship issue that is being disguised as a DRM issue. You're trying to use a law that criminalizes the process of breaking a digital lock on what you bought and fucking paid for to get content taken down that you don't like. And that's where I draw the line. I started my nonprofit last year to reform this bullshit law. This law is not about your petty fucking grievance. This law is not even about piracy. This law is about the fundamental question of, do you own what you bought and paid for in a world where a fucking baby monitor can get turned into a subscription? This law is an abomination and a stain on our country. I want to see it reformed. We've started a nonprofit with the intention of reforming. We have a bounty program where we go over different devices that have been disabled by the manufacturer that we are paying people to break open and make work again so we can demonstrate just how much damage this law does. We have a wiki with thousands of articles going over this. I have a staff of half a dozen people, quickly expanding, that are going to be working on this. Lobbyists, we work with lawmakers, and we will win. But something I'm also looking for is a test case. You see, there's a legislative route, there's the cultural route, but there's also the judicial route. To show that piece of your video, I used YTDLP. Would you like to sue me? I would love to test this case in court. Unfortunately, nobody has sued me yet. I would love to get a frivolous lawsuit. You have no idea. There are three types of people in this world. There are the people that go, no, please, I'll do whatever you say. I don't want to get in legal trouble. I'm afraid of getting fired. I don't want to get a legal letter. Oh, no. There are the people that'll go, yeah, you know what, I'll defend myself. And then there's people like me, the people that get into fights that don't even care if their nose gets broken just because they enjoy the taste of their own blood. Which type of person do you think I am? Fuck around and find out. I'm not sure if my nonprofit is going to be able to extend help in this particular case. It's almost midnight and I haven't had time to consult with everybody else. I'd like to make sure he's making the right arguments. And I sure as fuck don't want to see him give up because he runs out of money for a lawyer. That's for sure. If this case is won in Denver Metro Audits' favor, Section 1201 of the DMCA will be able to be used in every single censorship or takedown case you see on YouTube when people disagree with one another. This is so fucking petty and stupid. If he had simply had a monitor up, right? Like if he had just put the monitor up with Denver Metro Audits' video and zoomed his camera in on it, had the microphone up to the speaker, that would not have been breaking a technological measure. He could have done that. And then that part of the claim would have been gone. And we know that Denver Metro Audits' issue is not with the fact that he used YouTube DLP. It's with the fact that he was criticized by somebody. Let's be real here, because he would have gotten the same fucking point across. If you look at Frauditor Troll's channel, it's like 67,000 subscribers criticizing First Amendment audit. It's not like he makes his money off of selling bootleg copies of Blu-rays or people are only going to pay if it's perfect quality. He could have very easily criticized you by just having his camera filming his laptop. If you want to sue somebody for doing that, sue me. I'm admitting to doing it in this video, which is a defense that can't be made for Frauditor troll. I am not afraid of legal battles. I am not afraid of confrontation, and I am not afraid of getting my hands dirty. I would enjoy every second I spent on that case, because not investing in that right now is giving up freedom of speech into the future for every single person on YouTube. Because even if something technically is fair use, even if YouTube's own system, which is almost always in favor of the person filing the strike, says that your video can stay up, somebody just filed a claim saying, oh, section 1201, when we know that that wasn't even the problem to begin with. If you are a large content creator on YouTube, hell, if you're a small content creator on YouTube, and you've ever included somebody else's video within your video, this is very important to you, and I hope that you cover it. There are many people on this channel that have many millions more subscribers than I do that will do videos where they'll show a piece of somebody else's video. And you'll think, well, that's fair use. I didn't do anything wrong, right? Well, even if you didn't do anything wrong via fair use, if you used a downloading program or a screen capture program to obtain a copy of that video to put it into your video editor, you have broken a law that is punishable by 3 to 5 years in federal prison. There are many people on this platform, I know many of you exist that have much larger reaches than I do, that do videos regularly where you comment on other people's videos. There are hundreds of you. And if this affects you too, this is not just about some 60,000 subscriber YouTube channel, because when the judge rules in this case, if Denver Metro Audits continues to push forward with this case rather than drop it, they will be setting a precedent that has not been set before, that Section 1201 can be used to limit free speech and fair use on this entire fucking platform. That is a dangerous precedent to have set. We need as many people as possible on this platform to band together against this bullshit. This judge actually rules in favor of Denver Metro Audits. We are all fucked. I don't usually bother my audience to do this to people. Get other people to talk about this. Everybody on YouTube that makes content where they've ever been critical of somebody else's content needs to be made aware of just how fucked they could be if this case finishes in Denver Metro Audits' favor. That's it for today. And as always, I hope you learned something. I'll be following up on this case. I'll be watching very closely, and I'll be looking into what our nonprofit can do to help. Frauditor, you are no longer alone. Denver Metro Audits, you have made a big fucking mistake. That's it for today. And as always, I hope you learned something. I'll see you in the next video. Bye now.